Hello, welcome everybody. My name is Chris Schaefer. With me is my partner Lindsay Howard. Welcome to the SKO UCLE series. We're going to get started in a couple of minutes. I noticed that folks are still logging on, so I do want to give it another minute or two before we get going. So talk amongst yourselves, get your lunches out, whatever you want to do. We'll get going in just a minute or two. All right, it's a couple minutes after 12, and we all want our full ethics hour, so let's get on it. Again, my name is Chris Schaefer. I'm a partner at Stahl, Keen and Ogden. Do business litigation primarily, represent a lot of corporations, do a lot of fiduciary disputes, and in my spare time, historically, I have taught classes at U of L. I've taught trial ad, and I've taught the evidence course. And because I have this expertise in being a nerd, we're going to talk about the attorney-client privilege. And with me is my partner, Lindsay Howard. Lindsay does a lot of the same things I do, and I end up dragging her into a lot of those classrooms. She's coached trial teams with me, and we have done a lot of litigation together. So I'm just delighted to have her with me. For any of you that have been with us from the beginning, you know that during the COVID era at Stalking and Ogden, in order to stay in touch with folks and to see if we could give back a bit, we decided to establish a CLE series. We've been going for almost a year now, and we've come full circle. You had the what I hope was pleasure of listening to Lindsay and I talk about a different subject within the attorney-client privilege last year. This year, we're going to focus in a little more on the concept of business advice versus legal advice in the in-house setting, and I hope that will be of particular interest to you guys. Before we get into the substance of it, there are, of course, some housekeeping things we have to do. Number one, like all of the CLEs in our series, we are recording this, and it is being recorded with the intent that it will be posted on our YouTube page and offered up for other folks to be able to view it in the future. I'm told that the only thing that's recorded will be the PowerPoint slide presentations that hopefully you can all see on your screen, and a small image of Lindsay and I as we give the presentation. So you shouldn't have to worry about if your name is going to be on there or anything like that. But that way we all know what's happening. Following our webinar, you will get anywhere from one to a few emails from us. We will ask that you complete a survey. The survey is important to us. We really are trying to come up with programming that is relevant to your practice and helpful to you. The more information you can give us to tell us how these programs are working and what you might be interested in hearing, the better. So we'd really appreciate it if you took what shouldn't be more than 2 or 3 minutes To respond to that survey, you can look for it to come from the SKO marketing team. Um, with respect to CLE credit, we are pre-approved for credit in Kentucky and Indiana. You can see on the screen now the activity numbers. Don't worry, you'll get an email that has those in them as well. And then you'll be able to self-report those CLE numbers. And this particular program does count as ethics credit. So you will get an hour of ethics CLE credit in either or both of Kentucky and Indiana. Um, uh, Logistically speaking, I've been told by some sources that we are required to take roll. Make no mistake that you will have to self-report your hour, but at least one of the Bar Association asks that we send them a roll call. If you could do us a favor, because on our screen we can't see all the names of everybody, if you could just send us a chat to Lindsay Howard that tells us that you're here and give us your name. That's the easiest way we can take roll, and it also satisfies the need that you all have actively participated in some manner. Um, I think finally everybody knows these things, but with any of these kinds of Zoom or WebEx based functions, we ask that you stay muted unless you have a question. If you do have a question, you can send us a chat. You can send it to the entire group. You can send it just to Lindsay. Or you can use your raise hand function and we'll call on you. It is always helpful when we have some audience participation. It helps Lindsay and I know if we're on the right page or not. And frankly, it just makes it a little more interesting and engaging. Not that the attorney-client privilege isn't just riveting from the start anyway. A little audience participation always helps. So as we get going today, we're going to start with a little background on attorney-client privilege, but then we really are going to focus most of the hour on the distinction, and it's a very important one, between providing business advice in your role as an in-house attorney and providing legal advice, and what that distinction means for the purposes of protecting those communications. So Lindsay, if you'll get us started with just a basic refresher on the privilege.
Yeah, so as Chris mentioned, before we get into the more nuanced aspects of attorney-client privilege, we are going to give you a quick refresher. At the end of this presentation, if you feel like this refresher was not particularly helpful, this is something we often do. Please let us know, stick around, let us know. We'd be happy to abandon these next few slides going forward. We will not miss them, so just let us know. The basic idea underlying the attorney-client privilege is quite simple. The idea is that the things that you say to your attorney should be kept secret. As with all things in the law, though, this application of this particular doctrine is anything but simple. The basic rule is that confidential communications made between an attorney and a client for the purpose of giving or receiving legal advice are protected. This is pretty much the standard test everywhere with a couple of tweaks. The burden of establishing privilege is on the party that is seeking the protection of the privilege. And there are a couple exceptions to privilege in Kentucky. Those are codified at KRE 503D. Couple examples, although this is a little bit outside the scope of our presentation today, are issues involving a dispute with an attorney, such as malpractice, any communications made in furtherance of a crime or a fraud, or any kind of attested document. Attorney-client privilege was first recognized in the corporate context in Upjohn, in which the court acknowledged that the social good that arises from proper lawyering is outweighed by the need, is not outweighed, excuse me. So the social good arising from proper lawyering outweighs the need for full disclosure of facts. So again, the idea is to keep everything secret that you say to your attorney. But of course, there are some caveats to that rule.
You know, I think that we all, as lawyers and legal professions, we've got a basic idea about the attorney-client privilege. We have a general understanding that the communications we have with our clients are confidential. If we're providing legal advice, then that's protected from disclosure against third parties. And that frequently is the case with communications involving lawyers. But as we do the background, we want to make sure to remind everybody that you can lose that status. Things that would otherwise be confidential can be disclosed as a result of a waiver. And I think we all basically understand that there are a couple different types of waiver. You can have a voluntary waiver or involuntary waiver. A voluntary waiver of privilege is quite simply where you disclose it. You just voluntarily, whoever holds the privilege, discloses it to some third party that does not share that privilege. And the disclosure of that information can create a broad reaching waiver. It can waive, in some places, anything that relates to or touches on that communication or the particular subject matter thereof. Our presentation today is not focused on the breadth of that voluntary waiver. I will say, though, and ask you all to perhaps comment on this in those surveys, that is one topic that Lindsay and I have considered presenting on in the future, is the breadth of waiver. I get that question a lot from clients, and if that's something you'd be interested in having a full hour on, we'd love to hear that in the survey when you take that. But getting back to waiver generally, you can also have an involuntary waiver. You see an involuntary waiver where you've put the communication at issue. If you have used the communication as a sword or a shield in litigation, for example, in a bankruptcy proceeding, you have claimed that you relied upon the advice of counsel, well, that's become an issue. You can't just say advice of counsel and then not tell anybody what the advice was. So that's what's called an involuntary waiver. We remind everybody of this because it is important to our discussion of the in-house client, because we see so often that communications in a corporation can get away from us and they can be shared with a lot of other parties. And we want to remind you all and for you all to remind your client bases that disclosure of these confidential communications raises red flags and it can waive privilege. We will talk a little more in detail about that as we go through today, but we just want you to keep that in mind, that just because it starts as privileged doesn't mean it finishes as privileged. So inside of the in-house counsel concept, we see a couple of other really important questions. The first one is to identify who the client is. We all know that businesses and entities can only operate through individuals. They can only operate through the human beings that run the business, that work for the business, things of that nature. And historically, that can pose a lot of questions. So who inside of the company counts? Who gets to be the client for purposes of attorney-client communication? And historically, there was an analysis that essentially said it was the C-suite. It was the people who ran the business, who had decision-making power. And as time evolved, the courts realized that really wasn't capturing how corporate entities really work, because the people who make the final decisions don't necessarily have all of the information. And we need to let the other members of the corporation count as the client so that the lawyers can get all the facts so that they can be able to provide the best legal advice possible. That's resulted in the development of what's called the subject matter test. Again, not our purpose today to get totally into the weeds on that. So we'll basically leave it at this. If an employee is speaking to counsel within the confines of that employee's work, if it relates to what she does at the company, if she has information that is important and valuable to the legal advice being provided, then that employee counts as a member of the corporate client. So as long as the subject matter of the communication is within the role of that employee, it's safe to talk to the employee and get their information. As we go forward, we need to be careful about what the lawyer is giving back to that employee, because we can quickly get beyond the scope of employment for that person. We have a lower level individual. I like to use as an example the folks that drive the cars for the company, and maybe they've gotten in a car accident. Well, absolutely, they're the corporate client when the lawyer goes and talks to them to learn what happened in the accident. There's nobody else that could know that those facts are part of the scope of their work. They don't necessarily get to make the legal decisions about what happens as a result of the accident. And because of that, providing the legal advice back from counsel could create some issues as to confidentiality. We would just suggest that as politely as possible, you make sure employees understand that this is a need to know basis, and that you're there to gather information, not to provide them with information that you've gathered from others. A fine line to walk, but one that I think most of us are pretty comfortable walking. The second question that comes up regularly in the in-house context is who counts as the lawyer? There have always been questions over the years about whether in-house counsel are serving as lawyer and that their communications are privileged. Fortunately, that question has been answered in the affirmative. There is no doubt, certainly not in Kentucky, and I don't believe in any other jurisdiction, that in-house counsel do count as lawyers, do count as the attorney for the attorney-client communication privilege, so long as they are acting in their role as counsel and providing legal advice. It is not enough that that individual has a JD. It's not enough that they're a member of the bar, but rather, what's their role? Are they there to act as legal counsel to the company? If so, then absolutely the attorney-client privilege can apply. So big picture, that means that in the in-house setting, you've got an identifiable client that takes the form of any employee who has information about the subject matter of the legal advice that comes to them within the scope of their employment, and the in-house counsel is effectively the attorney in the attorney-client communication. Those are the big picture concepts, and that leads us right into the question for today's hour of, well, what's it mean to be providing legal advice versus some other kind of advice?
Right. So the issue that we're focusing on today is this idea that communications are only privileged when they involve legal advice. The role of in-house counsel has clearly evolved in recent years, but over the course of a long period of time. And in-house attorneys, from a practical standpoint, spend every single day in the hall, roaming the same halls as their colleagues who are business folks or who are staff members. This is super useful for the flow of information. This makes sense. This setup makes sense, but it makes things complicated in the context of privilege. So even though courts consistently say that the privilege applies to in-house counsel in the same exact way that it applies to outside counsel, as we've told you in the past and will continue to tell you in the future, that is not necessarily true. The reality is that the privilege applies differently in the in-house context. The most frequently cited basis for denying the protection of privilege is when an attorney serves in some sort of dual capacity. So the issue here is that courts presume that outside counsel are rendering legal advice when they're communicating with you. That's pretty much all that Chris and I do, right? So hopefully you hire us as your attorneys. We enter into an engagement letter that memorializes our relationship as lawyer and client, and then we provide legal advice in exchange for a promise of payment. Courts presume, in our case, that we're acting as your attorney when we're communicating with you. But courts don't make that same presumption in the in-house context. And the reason is because courts understand that as an in-house attorney, you're often asked to wear different hats. You attend board meetings. We don't often attend our clients' board meetings. You are often on the boards. We are never on our clients' boards. Because of that, the courts apply the privilege cautiously and narrowly in the in-house context. The overarching concern that courts seem to have is that a corporation will hire all of these attorneys, they'll put them on the payroll, they'll put them on every committee, every subcommittee, and they'll involve them in every conversation, whether it's legal or business related. And then they'll use those attorneys' involvement as a method by which to shut down discovery. As the Southern District of New York has explained it quite brutally, quote, because in-house attorneys are employees of their client and their livelihood depends on that single corporate client, in-house counsel are not as, quote, independent as outside counsel. It's kind of a rude way to put it. And the point is not to insult in-house counsel, but it's to offer insight into the harsh generalizations that courts apply in this context and the often harsh consequences of those generalizations. And so for these reasons, it is important for you to remember that business advice given by any attorney, but particularly in the in-house context, is no more protected than advice about the weather. That's going to be our focus today.
Yeah, absolutely. I will tell you that one of the bar associations requires or asks us to have some audience participation. So we're going to do that in what I hope is a very simple way. We've got a poll. If you all note from your screen in the tiny corner that Lindsay and I appear in, they don't trust me with a computer. I'm not tech savvy. So Lindsay is going to try to navigate us through a poll question that inquires with you all of how many hats do you wear? Do you wear different hats in your business? And does one of those include giving business advice? I'll be very surprised if there's a lot of no's to this question, because I think all of us are familiar with the need to give business advice in an in-house context. As Lindsay said, she and I get this luxury that all we do is practice law. We talk to our clients when they have a problem, and we try to advise them on the legal ramifications of it. We thus get a very nice presumption that when we're talking to you, it's so that we can get information and give legal advice. In fact, if you've had the challenge of working with me in the past, you've probably heard me say to you, look, man, that's a business decision and I can't make that for you. That's not my role here. I can only tell you what the legal consequences of those decisions are. Well, if you're the general counsel of the company, you don't really get that pleasant out. When the CEO walks in your office and says, all right, we need to talk about this. Here's our problem and here's our concern. And from a business perspective, what are we going to do? You can't say, I'm going to pass on that one. That's not really my job here. So it gets a little more blurry because folks that are practicing in-house do wear a lot more hats than those of us that practice in firms like Lindsay and I. So Lindsay, what do we have here for the folks that have played along at the home edition?
It should show the results.
All right.
But I'm not very good at this.
Well, I don't know if you can see them or not, but it looks like we've got about 50% of folks have said that they do, in fact, wear these different hats and they do provide business advice. A few folks have said they don't, but I'll acknowledge that I see some names on the screen that I know work in firms like mine. And then we've got some folks who haven't answered. But I think the takeaway is that the majority of folks in-house wear different hats. And that means we've got to figure out uh, when is your communication privileged and when is it not? All right, Lindsay, let's go ahead and take a look at the test. We can take the poll down to the extent that it's up. When courts look at this, there are easy ones. There's easy ones where the only thing happening is legal advice. Let's use our nice car accident case. The driver has gotten in an accident, a lawsuit has been filed, and as in-house counsel, one of your first jobs is to go and take statements to defend that lawsuit, to give to somebody like me. Well, that's easy. That's a purely legal question. But sometimes you've got a communication that can involve both legal and non-legal matters. And courts have decided that it will be privileged if the predominant purpose of the communication is to render or solicit legal advice. Well, like most things in the law, that's fuzzy. And probably doesn't provide you a ton of comfort, because who gets to decide what the predominant purpose of the advice was? Short answer is the judge does. But the judge doesn't necessarily understand your business or your motivations as well as you do. And it can make it uncomfortable. What I'll say is I'll give you a quote from the Southern District of New York. And like most issues that touch on evidence, a lot of the law in this area comes from the Southern District of New York. And in 1995, the court explained it that the fact that an attorney's advice encompasses commercial as well as legal considerations does not vitiate the privilege. If the attorney's advice is sought, at least in part, because of his legal expertise, and the advice rests predominantly on his assessment of the requirements imposed or the opportunities offered by applicable rules of law, he is performing the function of a lawyer. And that comes from a case called Note Funding Corporation v. Bobian Investments Company. And I think that the takeaway is, if you're applying the law to the facts and you're coming down and giving advice of what to do based on that law, then courts will say the predominant purpose is legal advice. And even if it blends in a little bit, because look, we all have to consider the business impact of our legal advice. But even if it blends in, that's still privileged. If the predominant purpose of your communication is to render legal advice, then it's privileged. And one of the ways that we as counsel can protect ourselves is to make sure our communications are clear. To say, when you write your email back to the CEO, when you write your report to the board, to say, you've asked me to analyze the following possibilities in light of this law or that law, and here are the legal considerations. You're going to throw some business advice in there. It's going to be mixed together, but make it clear that your intention is to provide legal advice with that business advice. And in fact, that's your predominant role, because that's what's going to keep it privileged. That's what's going to allow Lindsay and I to go into court and show the email to the judge in camera and say, look, even in the email itself, counsel was being explicit that they were talking about legal ramifications and they were basing their advice on the law. Its predominant purpose is legal, therefore it's privileged. With that in mind, our goal is to be as helpful as we can in the 30 minutes we have left, and just walk through some examples and walk through where we see these issues come up over and over again. Because hearing it in a vacuum like that isn't particularly helpful. Actually seeing how judges apply it is. So Lindsay, let's see what we can talk about in the specifics.
So as Chris mentioned, it should come as absolutely no surprise to you as people educated in the law that no single factor is dispositive in every case or even in any cases. So to torture ourselves and you, we'll go through a couple examples that illustrate exactly the kinds of close calls that courts often have in this context. Case study number 1 is a wrongful termination suit. The employee in that case sought records of 2 meetings of the personnel committee of the company. At the personnel committee meetings, managers discussed the termination of this employee with in-house counsel. The bylaws of the company in that case, and this ends up being semi-important, the bylaws of the company required an attorney to sit on each of the main committees of the company. But they stopped short of giving the attorney, the in-house counsel, a purely legal function. So the company asserts privilege over the communications had during these meetings. They refused to testify regarding the contents of the meetings. This seems like a perfectly reasonable position to take, but the DC District Court disagreed. Instead, the court held that when a corporate personnel committee asks about the legal implications of a proposed decision to terminate an employee, the primary business purpose of the meeting predominates over the legal issues. In other words, although legal review was part of the reason the attorney was there, it was merely incidental to the primary business purpose. So in dicta, the court said membership on a committee by an in-house attorney can actually lead to the inference that the attorney, at least in part, was acting in a non-legal capacity. That, in our view, is a pretty brutal presumption or inference for courts to make. In the second case, this case out of the Northern District of Ohio, a group of shareholders sues a company seeking notes regarding a presentation made at an audit committee meeting. Very similar to the last case. Again, an attorney, the in-house attorney, was present at the audit committee meeting, and the company refused to turn over notes that were taken during this meeting. So in that case, the Northern District of Ohio held that because the meeting served both business and legal purposes, the dual purposes couldn't be separated. And the court also stated that business and legal advice could frequently be inextricably intertwined, and the fact that business considerations are weighed in the rendering of legal advice will not vitiate the attorney-client privilege. This is the second time we've used that word in this presentation, and the second time a court has used it in their opinions. But put simply, the court found that advice provided by in-house to the audit group, because it included business considerations, was predominantly for business purposes. Now, these two cases have identical facts, virtually identical, and opposite holdings. So how do we reconcile the two cases? The answer to the question is we don't. It's not surprising, but we don't. The reason we presented these two cases to you is because they illustrate this kind of the balance that courts have to strike between whether something's protected and whether it's not when it involves an in-house attorney. It illustrates that it's completely up to the court to make a judgment call on that balance. And the tipping point is still very clearly unclear, as illustrated by these two cases. So 2 things we can definitely tell you for sure. Number 1, an attorney's participation in a meeting does not automatically render what's said at that meeting privileged. Number 2, it's really important to err on the side of caution in this context.
I really struggle with that first case and the notion that an attorney who is specifically saying legal ramifications for termination would not be privileged. And the best way that I can rationalize that out, and it is nothing more than trying to rationalize it out, is the broader perspective that that attorney was participating in the entirety of the business decision about whether or not to terminate. They weren't there just to provide the legal advice. They weren't sought. There wasn't a separate memo that went out. They weren't brought in separately to say, here's what we as a business are thinking of doing. This is our business goal. What's your legal advice regarding that? And I think that maybe if it had separated out, it would be that way, because courts are very reluctant to apply a blanket privilege simply because of the general participation of counsel in an otherwise business meeting or in an email chain. I mean, how often do we get emails that our clients say, oh, this is privileged. I copied John on it. And John happens to be the in-house attorney, but John never weighed in. John had no legal advice to give. This happened to be the CEO and the CFO talking about what their next step was. And I think courts do have a bit of a knee-jerk to that, to say, no. Just because you were there, just because you got copied, that's not enough. So that's the best way that I can try to rationalize out why the court would turn it over in that first case that Lindsay discussed. So we're going to try to walk through some basic rules that we have gathered from various court opinions that we see as recurring themes that you can keep in mind and try to apply to your practice or the practice of others in your legal department. Or frankly, some of you don't even practice in a legal department. You might have a different title or role. We often see attorneys who have roles in the human resources department or in the marketing and communications department. And then it gets even more complicated. So the first one is courts look at whether or not the advice or service being rendered could be done by non-lawyers. And that's a pretty simple rule. The Vioxx litigation, the multi-district litigation case that was eventually housed down in Louisiana, came out with a pretty good analysis of this issue. And they said when non-legal departments of a corporation primarily concerned with technology, science, public relations, or marketing make comments among themselves about matters within their corporate responsibilities, those communications are not protected by privilege. So when lawyers make the same comments about technology, science, public relations, or marketing, a different result is not warranted. And we do see that a lot. We see I remember having a client who, not a particularly large business, so they had a general counsel / CFO. And that created lots of hats for that person to wear. We see it a lot with people who are directors of marketing departments or human resources departments. And if you look at it and you say, well, they really had a meeting that was focused on marketing. They really had a meeting that was focused on technology or science, and there was merely the participation of a lawyer, that does not make it privileged. Those same decisions could have been reached, the same analysis could have been done by a marketing team that was made up exclusively of non-lawyers. And if that's the case, then we shouldn't expect there to be privilege, because the non-lawyer team wouldn't be privileged. Just because you stuck a JD in there does not make it privileged. I think this rule is a pretty simple one to look at and to ask yourselves, okay, would we have non-lawyers doing the same thing? And if the answer is yes, then you're probably erring on the side of no privilege. All right, our second rule.
So rule number 2, if the communication would not have been privileged if made to the attorney, it did not become privileged just because it was subsequently forwarded to the attorney. This rule might seem obvious to you, but it is a direct quote from a Kentucky Supreme Court case. So we thought it was worth repeating. The same goes for the privileged label. So number 1, with this rule, courts look to a lot of factors when they're trying to determine whether or not legal advice was the predominant purpose of a communication, and whether or not the communication was forwarded to an attorney is not one of those factors. As I mentioned, the same goes for the privileged label. Just because you label every calendar invite privileged doesn't mean a court is going to see that label and automatically decide, oh, well, we don't need to talk about this any further. It must be privileged. Courts look to a number of things. They look at the substance of the communication. Does it involve, for example, cost information? Does it include technical data? Does it discuss lobbying efforts? These are types of subjects that are consistently determined by courts to be business related. What's the purpose of the communication? Why was it written? Who are the participants in the communication and what are their titles? It's often helpful to use an attorney's title when you're talking to them about legal advice, and to take from the signature line, for example, that you're on. So if you're the attorney, that you sit on the personnel committee, take that off of the signature line when you're rendering legal advice alone. I know that's frustrating, but it helps. It weirdly helps a lot. Always give yourself a quiz. When you think there are mixed legal and business purposes for any given communication, give yourself a quick quiz. Ask yourself whether an email or a document that was forwarded to you would have been sent or prepared, whether or not you received a copy of it. If you're not an active participant in the creation of that document or in the communication about that document, then it is safe to assume it's not going to be privileged. In an opinion handed down just a little less than 2 months ago by the Eastern District of Kentucky, this analysis was applied in quite a bit of detail. The court needed to determine in that case what fit within the category of communications, quote, related to the pursuit of legal advice. And the court itself in that case described this category of communications as somewhat amorphous, which is pretty telling. The case involved a third-party subpoena. It also involved outside counsel, so it's a bit outside the scope of today's presentation. But the court helpfully reiterated in that case that it has a responsibility to, quote, dissect the identified document sets with a scalpel, separating mere identification data from substantive communications about the underlying legal problem, which careful delineation is supported by case law. The court then proceeded in that case to analyze just about every single page of every single document at issue. So it's important to keep in mind that courts are taking a scalpel to these communications.
Which brings us to rule number 3, which comes right out of that concept of a scalpel to it. Sometimes our communications do have both. There is both a business policy and a legal evaluation. And I think usually as lawyers, we like to assume that if we've got something privileged in there, we just get to put a nice big stamp on the top of it that says privileged, and the whole thing goes away. Nobody gets to see it. We just call it a day. And the scalpel analysis tells us no, that's not the case. We are very likely going to end up in a situation where the court's going to review it in camera and is going to pick it apart and say, well, paragraphs 1 and 2 do in fact provide legal advice, but paragraphs 3 and 4 don't. Paragraphs 3 and 4 are business advice, and therefore we're not going to protect those as privileged. And we see that more and more in the in-house setting than we do in our firm type of a setting, because we can usually argue that everything in our email is legal advice, and courts are a little more skeptical if an in-house attorney is wearing multiple hats. And so it's not really uncommon. It's what we do all the time when we have to redact privileged portions of emails and where we have to cross out before we produce things. We do it constantly when we do discovery. So this shouldn't be a total surprise. Portions of your emails might be privileged and portions might not. I'll say that one area in particular where I see these issues come up, especially with the concept Lindsay was discussing about sending something to counsel does not necessarily make it privileged, is in contract negotiations. We see the business folks are negotiating with a third party and they're exchanging drafts of contracts. And I've had plenty of clients who have said, well, I sent that draft to the lawyers to give me legal advice on it. That doesn't necessarily mean it's privileged. A better practice might be to, before you draft it, send an email to the lawyer or have a call with the in-house lawyer to say, I'm considering drafting a provision of a contract about A, B, and C, but I need your legal advice before I do so. Because courts can look at those drafts and say, you didn't draft that for legal purposes. You drafted that to enter into a business deal. It wasn't your intent for that to be privileged. It's a lot harder to say that if you've gone the extra step and you've expressly asked the lawyer, I would like your legal advice about this thing before I put it into my business document. And I think that's important. And it can help us keep separate these business and legal advice concepts so that we're not having to produce redactions on a small scale, but we can rather protect the entire communication. Because I think the intent is, I want legal counsel to tell me, is this a real dumb idea, legally speaking, before I put it in this contract? And if it is, we want to keep that out of the hands of the other side. We want that to be privileged. We don't want them to know that we thought about this but decided not to put it in. In order to maintain that privilege, we need to keep it clear that we were asking for legal advice, not just revising and drafting contracts that we were going to use for our business purposes. All right, so our fourth and I believe last of our rules.
Yeah, so this is the slide where we contradict ourselves entirely, because there's always at least one of those. Rule number 4 says that sometimes legal advice can and should entail business-related concerns. Sometimes it is necessary for legal advice to entail business concerns. We all know that. We've all been in that situation, outside counsel or in-house counsel. As the court said, the Kentucky Supreme Court in Lexington Public Library, client communications intended to keep an attorney apprised of business matters may be privileged if they embody an implied request for legal advice based thereon. It is very important for you to remember that only God and the court know what an implied request for legal advice is. So as far as Chris and I are concerned, and in our opinion, as far as you should be concerned, no such thing exists. It is safest to assume that there is no implied request for legal advice in your communications with a client, even if your client is the company. You should keep in mind the rules that say the predominant purpose has to be for legal advice. But you're not limited to this kind of abstract advice about how the rules of law apply in a vacuum. Again, this contradicts everything we've said, but courts can go either way on this type of advice. So it is really important that you're proactive when you give advice that includes business-related concerns.
Well, it's always nice when we can be as confusing as possible. I tend to sit at the end of the hour and go, ooh, I'm not sure what I think, much less what anybody else thinks. But such is the law. I mean, we all know that. We're lawyers and we understand that there's a lot of gray in what we do. Our goal is to just help you understand as best we can where the pitfalls are and what can help you get protection. So we're going to look at a few consistent bases for rejection of privilege. We've talked about most of these already. A little bit of review here. Number one is the counsel that serves in the dual role. That's our CFO/GC. It's our director of human resources who is also legal counsel. It's our head of public relations who happens to have a JD. Courts tend to be very skeptical of those dual roles and tend to ascribe to them non-legal purposes because, as we looked at in one of our rules, there's plenty of non-lawyers that serve those functions. And as a result, just be careful with that. Make sure that if you are truly acting in your legal role, you're specific about it. Communicate that up front and say, the purpose of this email is to provide my legal advice regarding whatever it is. The more upfront and the more direct you can be, the better. The second of our consistent basis for rejecting privilege is documents reviewed by business teams. These are our contract examples where the contract is being sent to a team of 7 people and it's simultaneously being reviewed by the in-house counsel. So one of the 7 recipients happens to be the assistant general counsel who examines contracts, but the other 6 are business advisors. The back and forth that we see, and we see it all the time, where people are trading red lines and coming back and saying, what about this? Oh, I like this, I like that. It's pretty hard to sell that that's purely for legal advice when in reality land, the in-house counsel hasn't commented and certainly isn't commenting on each one. And rather the business folks are talking about what they want to do from a business perspective. Those documents don't get that privilege stamp as much as some of us might hope or think they should. Next would be ambiguous advice sought from counsel. These are our mixed purpose communications. If it appears to be mostly commercial or even about the same commercial as legal, then you're not going to get that protection for the commercial advice that's given. The second is the simultaneous legal and non-legal review. Same concept. If you're sending it to a bunch of folks on your team and only one of them happens to be in the legal department, don't expect that chain to be privileged, especially if you all are directly communicating back and forth rather than this is an email to counsel and I've copied the other business professionals because I want them to know what counsel's advice is. That direct business to business engagement on those reviews is not going to be privileged. Our next one is chain emails. I see this all the time where you've got a long chain that has a lot of discussion that really isn't legal advice, and then it gets forwarded to the lawyer and they say, you know, hey John, can you take a look at this? Is this a legal issue? Can you let us know? And then I'll have a client that says, no, we sent it to John. It must all be privileged. Stamp it. Well, not so much, because those interchains were not communications with a lawyer. They were business communications back and forth. Now, that email where you sent it to the attorney and said, we've got a question, can you help us with it? That and his or her answer, absolutely, that could be legal advice. But it's like the scalpel discussion. We're going to redact that portion, but have to present the rest of it. Drafts of non-legal instruments. I don't know that I can beat the contract horse anymore, but the same concept. I see this a lot in policies and procedures. We drafted a new policy and procedure handbook, and at the end of it, we decided to ask the lawyer what she thought. Well, that doesn't necessarily make the whole thing privileged. It doesn't make your drafts privileged per se. It could privilege some communications about the drafts, could privilege some of the advice of the lawyer, but the drafts themselves are very likely not going to be privileged. And then last is just cover emails, simple emails to and from counsel that are the sole function to provide a cover for an attached document, and that document's not privileged. Well, the cover's not going to be privileged as a general rule. And so just keep those kinds of things simple and short and know that they are very likely going to be discoverable.
Just real quick before we open this up to questions, I think we've got about 5 minutes left. We have a little bit of advice regarding how to avoid the trap of legal versus business advice in the courts. Number one, I've already talked about this. If you can include Esquire at the end of the name when you're giving legal advice, or you can instruct your clients who are in-house counsel to do the same. It's helpful. It's not going to be determinative, just like a privilege label, but viewed in light of the totality of the circumstances, it is helpful. If you provide business and legal advice, if you need to provide both, then try to provide them in separate communications. It's much easier to parse them out. There's much less of a threat of disclosing information that you didn't intend for your adversary to see. Already talked about the attorney-client and privileged stamp. Don't overuse it. It will cut against you in a privilege fight if you label every single thing attorney-client privilege. Make sure that you make the inclusion of legal advice explicit when you are giving both, or really any time. In an email, for example, earmark it. Say, here is what the law says, or here's my legal advice. That way, if the court does have to go through with a scalpel and pick apart the legal portions from the business portions, it is much easier to find those legal portions. And where absolutely critical to protect privilege, you should involve outside counsel. I know this sounds like a self-serving statement, but we found this recommendation on the ABA website. It is important that if you want something to be protected, that presumption is really incredibly helpful. So it's important to involve outside counsel when you're really trying to protect something.
We really hope that this is helpful more so than it is a hindrance to, sometimes you get overwhelmed with information. I find that these things can be scary. That's not our goal. We don't want you to be scared of communications. We don't want to make it sound like there's any less of a legal function to being in-house as opposed to outside. We just want to arm you so that you know that these issues do exist. Now, we do have a couple of minutes left. It's always difficult to judge because you got this requirement to get the full hour so everybody gets credit, and you don't know if you're going to get any questions. But let's see if we've got a few questions here. So we've got a question that asks us to discuss the challenges of in-house counsel during an investigation with employees and the duty to disclose who the attorney is representing, who's the client in the context, and how does that work? You referenced a case that was from 6 months ago. I'll tell you that off the top of my head, I don't know that, but I do know the generals of what you're saying. My view on an in-house investigation is that perhaps the most important thing is the corporate Miranda. And the corporate Miranda is where you tell that person, I represent the business. I represent the business, not you individually. I expect this communication to be confidential. I'm here in order to get information from you that I need in order to provide legal advice. And it is important that anything we discuss here remain confidential. Don't go talking about it with others, even here at the company. Don't go home and talk to your spouse about it. This is intended to be a confidential communication. I think that warning is very important. If you don't give it, you can get folks that are confused, folks that think, well, this person's here to represent me, and so I can tell them anything, and it won't be used against me. And that's not the case. You're there to represent the business. Courts sometimes also advise that you set up lower level meetings like that with supervisors, that you as counsel go to their direct reports and say, I need to talk to Joanne about this incident that occurred so that I can give legal information. Can you set that up for me? And that helps keep it a little more formal and helps keep it in that vein. Make sure that if you're sending somebody who's not a lawyer, that you have papered up the direction to do so. Sometimes our legal departments might include paralegals, or we might have an investigator even that is part of the company. If there's lots of these kinds of things, just make sure it is very clear on paper that you as counsel are directing that investigation to occur and it's intended to be confidential. We have a question about a member of a board waive the attorney-client privilege for the entire board. Obviously, I know who asked that question, and she's asking it to me because we have that concern. And I'll tell you that generally speaking, decision makers do have the ability to waive, but it's not a guarantee. So it's kind of a case-by-case analysis, and we can certainly talk about that more offline from the person who inquired there. We are at 1 o'clock. We have filled our hour. Obviously, Lindsay and I are more than happy to stick around to answer anybody's questions, but we don't want anybody to feel like they need to stay any longer. We appreciate everybody's participation today, showing up. Hope these are useful. We plan to continue the series. Keep an eye out in your email for our next installment, which we plan to be a look at how COVID-19 has impacted litigation. That'll include such things as force majeure clauses and other issues of litigation that have arisen as a result of COVID-19. We don't have an exact date yet, likely going to be end of August or early September, so just keep an eye out on your emails for that.